Good morning, everyone. Everybody hear me okay? All right, getting some nods there. All right, we have, looks like we've got everybody here. Mr. Court Reporter, are we ready to go, sir?
You're on the record, Your Honor. Thank you.
All right. Good morning, everyone. My name is Chuck McLean. I'm the Chief Public Utility Law Judge at the Maryland Public Service Commission. Today's January 28th, 2022. We're here, and it's approximately 10 o'clock in the morning. We're here in case number 9670, which is captioned in the matter of the application of Delmarva Power and Light Company for an increase in its retail rates for the distribution of electric energy. And we're here on the recently filed settlement. Why don't we start with appearances first? We'll start with the company.
Good morning, Your Honor. Matthew Seegers appearing for Delmarva Power. I would also like to enter the appearances of Miss Kimberly A. Curry, Douglas E. Mikeel, and Taylor W. Beckham.
Good morning, sir. OPC?
Morning, Your Honor. Joseph Cleaver on behalf of the Office of People's Counsel. I'd like to also enter the appearances of Gary L. Alexander and Daria Pugh.
Good morning, sir. We have Walmart.
Good morning, Your Honor. Barry Naum from the law firm of Spillman, Thomas & Battle, representing Walmart, Inc.
Good morning, sir. And finally, staff.
Good morning, Your Honor. James Greger on behalf of staff. I would also like to enter the appearance of Catherine Moriarty and Michael Dean.
Good morning, sir. All right, so I understand there's a settlement. I appreciate all the parties' efforts in working that out. And I appreciate everyone being here. I do just have a couple clarification type questions. Why don't we start with the company? Mr. Seegers, you want to just kind of run through your exhibits and we'll get those admitted, and then we can go to the other parties, and then I can ask a couple questions.
Absolutely, Your Honor.
Thank you, sir.
The notice of publication for the pre-hearing conference, that was marked as DPL Exhibit number 1. So we will be starting with DPL Exhibit number 2, Your Honor.
Yes, sir.
And that will be the direct testimony of Kevin McGowan. DPL Exhibit 3 is the supplemental direct testimony of Elizabeth Morgan Downs O'Donnell. DPL Exhibit 4 is the direct testimony of Mr. Jay Zeminski. DPL Exhibit number 5 is the supplemental direct testimony of Mr. Jay Zeminski. DPL Exhibit 6 is the rebuttal testimony of Mr. Jay Zeminski. DPL Exhibit 7 is the direct testimony of Mr. Ken Barcia. DPL Exhibit 8 is the supplemental direct testimony of Mr. Ken Barcia. DPL Exhibit 9 is the rebuttal testimony of Mr. Ken Barcia. DPL Exhibit 10 is the direct testimony of Mr. Adrian McKenzie. DPL Exhibit 11 is the rebuttal testimony of Mr. Adrian McKenzie. DPL Exhibit 12 is the direct testimony of Mr. Ned Alice. DPL Exhibit 13 is the rebuttal testimony of Mr. Ned Alice. DPL Exhibit 14 is the direct testimony of Mr. Daniel Guy. DPL Exhibit 15 is the rebuttal testimony of Mr. Daniel Guy. DPL Exhibit 16 is the direct testimony of Miss Kristen McAvoy. DPL Exhibit 17 is the supplemental direct testimony of Miss Kristen McAvoy. DPL Exhibit 18 is the rebuttal testimony of Miss Kristen McAvoy. DPL Exhibit 19 is the direct testimony of Mr. Michael Normand. DPL Exhibit 20 is the supplemental direct testimony of Mr. Michael Normand. DPL Exhibit 21 is the rebuttal testimony of Mr. Michael Normand. DPL Exhibit 22 is the surrebuttal testimony of Mr. Michael Normand. DPL Exhibit 23 is the supporting data filed by Delmarva Power in this proceeding. DPL Exhibit 24 is Delmarva Power's Notice of Public Hearings, which was filed on January 11th in this proceeding. And for the final DPL exhibit, Your Honor, is the settlement testimony of Miss Elizabeth M.D. O'Donnell. That is DPL Exhibit number 5. And I would also like to enter in the as joint exhibit number 1, Your Honor, the settlement agreement that was filed on behalf of all the parties in this proceeding.
Okay, thank you, sir. That was going to be one of my questions. I appreciate you bringing that up. So we'll mark those exhibits as Mr. Seegers had requested, and I presume there's no objection to the entry of those documents. All right, I see a lot of shaking heads. So those documents are admitted. Mr. Cleaver, did you want to go for OPC, sir?
Yes, Your Honor. Thank you. Your Honor, Mr. Guerin, per Your Honor's request, is here today to answer questions, and he also has a minor correction to make to his supplemental testimony. So would you prefer me to go through the litany with Mr. Guerin with respect to his testimonies and to just put the other ones in now per stipulation? Or do you want me to put Mr. Guerin's in as well now too, with the exception of the one with the correction, and let him do that? Whatever Your Honor prefers.
Why don't we run through them and we can hold Mr. Guerin, the one you're going to make a correction to, until he testifies, and we'll go through staff and Walmart, and then I'll call Miss O'Donnell, and then Mr. Guerin can make the correction.
Yeah, very well, Your Honor. That'll work for us. So, Your Honor, per the exhibit list that Ms. Pugh provided to Your Honor earlier this week, OPC Exhibit 1 is the direct testimony of David J. Efren. OPC Exhibit 2 is the surrebuttal testimony of David J. Efren. And OPC Exhibit 3 is the supplemental testimony of David J. Efren. OPC Exhibit 4 is the direct testimony of James S. Guerin. OPC Exhibit 5 is the surrebuttal testimony of James S. Guerin. OPC Exhibit 6, I will skip per the discussion. OPC Exhibit 7 is the direct testimony of OPC witness Glenn A. Watkins. OPC Exhibit 8 is the surrebuttal testimony of Glenn A. Watkins. OPC Exhibit 9 is the direct testimony of OPC witness Melissa Whited, updated on December 7th, 2021. OPC Exhibit 10 is the surrebuttal testimony of Melissa Whited. OPC Exhibit 11 is the direct testimony of David J. Garrett. OPC Exhibit 12 is the surrebuttal testimony of David J. Garrett. OPC at this time requests that OPC Exhibits 1 through 5 and 7 through 12 be entered into the evidentiary record.
All right, they are marked as council had requested. Any objections? Seeing some shaking of heads, they are admitted. Thank you, Mr. Cleaver. Mr. Nom.
Yes, thank you, Your Honor. Walmart has a single exhibit in this proceeding, and that is Walmart Exhibit 1, which is the direct testimony of Alex J. Cronauer. We would move for admission of that exhibit.
All right, we'll mark that as Walmart 1. Any objections to that? Again, seeing none, Walmart 1 is admitted. And sir, I apologize for even making you put a list. It didn't hit me until you responded with your one item. So I should have exempted you from that requirement. So my apologies.
Oh, thank you, Your Honor. It was no trouble whatsoever.
All right. And finally, Mr. Greger.
Thank you, Your Honor. Our joint testimony, what has been pre-marked as Staff Exhibit 18, also had a typographical error. I don't know if you were planning on calling Dave Hoppick and David Valkerinja to the stand today, so how would you like to handle that?
You know, why don't we just handle that at the end? We'll call them, you know, they're here, Mr. Hoppick's up, so what we can just handle it when you call them, similar to Mr. Cleaver.
Yes, sir.
Right.
In that case, pursuant to the exhibit list submitted by staff on Tuesday of this week, Staff Exhibit 1 is the direct testimony of David Hoppick. Staff Exhibit 2 is the rebuttal testimony of David Hoppick. Staff Exhibit 3 is the surrebuttal testimony of David Hoppick. Staff Exhibit 4 is the direct testimony of Hulan Lee. Staff Exhibit 5 is the surrebuttal testimony of Hulan Lee. Staff Exhibit 6 is the direct testimony of Roger Austin. Staff Exhibit 7 is the errata to the direct testimony of Roger Austin. Staff Exhibit 8 is the surrebuttal testimony of Roger Austin. Staff Exhibit 9 is the direct testimony of Lucy Shea. Staff Exhibit 10 is the surrebuttal testimony of Lucy Shea. Staff Exhibit 11 is the direct testimony of Mark Riley. Staff Exhibit 12 is the surrebuttal testimony of Mark Riley. Staff Exhibit 13 is the direct testimony of Drew McCullough. Staff Exhibit 14 is the rebuttal testimony of Drew McCullough. Staff Exhibit 15 is the surrebuttal testimony of Drew McCullough. Staff Exhibit 16 is the direct testimony of David Valkerinja. And Staff Exhibit 17 is the surrebuttal testimony of David Valkerinja.
All right, we'll mark staff exhibits 1 through 17 as council requested. Any objection to their admission? Again, seeing none, they are admitted.
Thank you, Your Honor.
All right. Thank you, sir. All right. Is Ms. O'Donnell with us? Yes. She was here early. She gets extra points for that.
Thank you.
Ma'am, can I get you to raise your right hand? You swear or affirm under the penalties of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am. Can you please state your name and spell it, please, for the record?
The whole thing. Okay. It's
Just go with
it's
Morgan
a-
O'Donnell as you're showing up, ma'am.
sure. It's Morgan O'Donnell. MORGAN O''DONNELL.
Thank you very much, ma'am. I appreciate that. And again, I appreciate you being here. I just had a couple kind of clarifications. And the first one is going to seem like a silly question to me or to probably most folks on the phone. On the third page of the settlement, it discusses the system average increase and how the different rate classes are going to be received either the system average increase or 1.5 times the system average increase. Can you tell me what exactly the system average increase is?
I'm not a rate design expert by any means.
That's fine.
But what I believe it to mean is that there's an average increase across the classes, and
Sure.
there's a multi-step process and that is applied in the 4-step method.
Right.
by
I just
Mr.
wasn't
Normand.
sure if there was an actual figure. That's kind of what I was looking for. but
I
maybe-
don't know what that is, but I
That's okay.
imagine we could certainly provide it to you.
Okay. All right. Maybe Mr. Hoppick can help us out on that. All right. For the vegetation management credit that's discussed on pages 4 and 5 of the settlement, and I know
Yes.
this was not, it did not appear to be a contested issue. Am I correct that the allocation of the credit is going to be consistent with Mr. Norman's testimony in his exhibits, ma'am?
It's going to be consistent with the revenue allocation in the last rate case, which is 9630. Is that
It's I think that's correct, but he had an exhibit, I think it was MTN-1, page 14, where he had the allocations. But yeah, you're correct. I believe you're correct that it was based on 9630. I just
yes?
was wondering if those numbers were still the same, ma'am.
I believe that they are.
All right. And again, that's what I figured, but I just wanted to make sure. On the closing of the rate class and the extension of the eligibility for the R-TOU-P rate schedule, are you, how does the company intend to kind of advertise that, ma'am?
But
Letting customers know.
I don't know. I imagine that we will the tariff language will obviously be updated to the extent that we market it. I'm not sure what we will do, but I do believe that we will try to notify customers through customer care talking points as to their optionality so that they understand that they have an opportunity to save through the pilot time of use if they would like.
Right. Does the company see this more as just I don't want to say an accommodation, but a way for the current, the time of use customers whose rate class is closing, another option for time of use rates? Or do you also see it as a way to get new customers into that rate class, ma'am?
I think obviously if we're extending the time period in which folks can join customers can join the pilot, I think that's a good opportunity. But I would say the real intention was to give the customers who are on the time of use non-demand or ND class the opportunity to go to the other time of use rate class so that they have opportunity to save money.
Okay. All right. Thank you, ma'am. And with respect to the R-TOU-ND rate class, I believe the company has agreed to make a new proposal in their next rate case. Is that correct, ma'am?
That is correct.
So that'll be ready for the multi-year rate plan?
Yes, that our intention is to file in May, as stated in previous testimony. So that would most likely be our next base rate case.
Right. Yeah, and again, that's what I figured, but I appreciate you confirming that. And just a general question on the multi-year rate case. Why, the ink's going to be barely dry on this one. Can you tell me why the urge or the need to file a multi-year rate plan so quickly after these rates? Well, they won't be in effect very long.
I think the company, as stated in Kevin Witness McGowan's testimony previously submitted in this filing, which I adopted, the company is supportive of multi-rate plans. They think alternative rate making is the way to move forward for the company. We did want to file it earlier than expected, but we wanted to allow time for the lessons learned process and our ability for DPL to react to commentary that was made by the commission in the Pepco Maryland and BG&E MYP orders.
All right, thank you, ma'am. I have one final question for you. And it's a statement that Mr. Guerin made in his testimony.
Okay.
And this is obviously subject to any changes he might make later. So, and I'll read you the phrase, and for anyone follow along, it's page 4. It starts on line 12. It states, while the company and OPC have significant differences of opinion as regards to the actual future of future net salvage, both parties agree that the use of a regulatory asset is fair and mutually agreeable way to address the company's unusual reserve imbalance. And there's a comma brought about by an uncommon degree of storm activity. And it's that last phrase. Was it does the company agree that, I guess part of the reason for the large imbalance was for the unusual storm activity?
Yeah, I believe so, but I think obviously we use the commission precedent for the Maryland present value methodology. The company believes that that through that methodology, we can't address the net salvage asset as quickly as we would like, and so this gives us an opportunity to address what is a relatively high balance.
And I'm going to ask you to look into your crystal ball here. Do you, I mean, given the regulatory asset, the agreement for that, I mean, I know that I guess it addresses the issue, the imbalance now. I mean, do you foresee a situation where we're back in the same scenario in another 10 to 12 years, ma'am?
I think the company has been clear in their position, but for the purposes of the settlement, I think the parties have reached a mutually agreeable position, so that we can address the current balance, and then we'll need to, in future proceedings, address it in terms of how does the commission's precedent valuation impact that balance going forward. So I think I would imagine our position is it would continue to build, but I also can't predict the future
Sure.
myself. So
Understood, ma'am. And it's not really a fair question, I guess, but I just wanted to ask it anyway. So I apologize for that. I don't have any other questions. Does Mr. Seegers, do you have any questions for your witness?
None, Your Honor.
It's my witness, I should say. Mr. Cleaver,
No questions. Thank you.
Mr. Nam,
No questions, Your Honor.
thank you, sir, and Mr. Greger.
Nothing for me, Your Honor.
All right, thank you. Thank you very much, Ms. O'Donnell. I appreciate you being here today.
thank you very much. Have a good weekend.
You too, ma'am. All right, Mr. Garrett, how are you doing today, sir?
I am doing well, thank you, Judge.
Very good. Can I get you to raise your right hand, please, sir? Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much, sir. And can I get you to state your name and spell it, please, for the record?
Yes, my name is James Shea Guerin. That's Garren.
Thank you, sir. Mr. Cleaver, did you want to touch on that correction, sir?
Yes, Your Honor. Thank you. Good morning, Mr. Guerin.
Good morning, Mr. Cleaver.
Mr. Guerin, as you heard, your direct and surrebuttal testimonies were previously entered into the evidentiary record by stipulation. I would like to ask you about the third testimony you filed. Do you have before you a document entitled Supplemental Testimony of James S. Guerin on behalf of the Office of People's Counsel, pre-filed in this proceeding on or about January 24th, 2022, comprising about 5 pages of narrative testimony?
Yes, I do.
Your Honor, I would request that Mr. Guerin's supplemental testimony be marked for identification as OPC Exhibit 6.
It should be so marked.
Mr. Guerin, with reference to this document, was it either prepared by you or under your direction or supervision?
Yes, it was.
And thank you, Mr. Guerin. With respect to this document, do you have any corrections or deletions to make at this time?
Yes, I do. On page 4 of my supplemental testimony, starting at line 18 and going to line 19, there's a sentence that reads, "In addition, a settlement on these issues at this time avoids all parties having to incur lower rate case expenses." And that should in fact read, "Settlement on these issues at this time avoids all parties having to incur higher rate case expenses."
Thank you, Mr. Guerin. Is that the only correction to make to your testimony at this time?
Yes, it is.
Mr. Guerin, with respect to this supplemental testimony, if you were asked today the same questions posed in this document under oath, would your answers be the same?
Yes.
And for these reasons, do you adopt your prepared written supplemental testimony as your sworn testimony in this matter?
I do.
Your Honor, OPC moves for admission of OPC Exhibit 6 into the evidentiary record with the correction.
All right, thank you, sir. It shall be, any objections? Seeing none, it's admitted. Thank you, Mr. Cleaver.
Thank you, Your Honor.
Mr. Guerin, I just had some kind of general questions about the depreciation and the regulatory asset. Now, 14 years seems like a awfully long period for amortization. Would that be fair to say, sir, in your experience?
It really depends on the context, Your Honor. I would say that I've seen amortizations of regulatory assets, depending on the size and the nature of the amount, the cause of the amount. I've seen amortizations ranging from anywhere from 5 to 30 years. Just thinking of an example of the cases of many legacy meter stranded costs when switches were made to smart metering. There were a lot of unrecovered costs and amortizations made for those kinds of accounts, and I saw amortizations ranging from, I would say, 10 to 30 years in various cases.
Okay, thank you, sir. So DPL or Delmarva is going to collect approximately 6.1 million from the regulatory asset plus whatever depreciation from the new rates each year. And that's obviously not an issue of double recovery. And you note in your testimony that the rates will be, maybe I'm paraphrasing, please correct me if I'm wrong. The rates will be lower each year in theory as the amortization reduces. Is that because it's coming off a rate base?
I don't believe that let me think about that for a moment.
Okay.
You may be thinking of where I said in testimony that the rates are somewhat lower, setting aside the regulatory asset amortization. The rates are somewhat lower than they would otherwise be because at present the reserve imbalance is in depreciation reserve and resulting in higher depreciation rates because it's lowering the reserve amount. And so taking this reserve imbalance out of the accrued depreciation for the remaining life calculation results in lower rates, setting aside the amortization. Does that answer your question, Your Honor?
Yeah, it does. It does. And I apologize if I misunderstood, but what you said makes sense. I mean, this is a crazy topic anyway. So I guess the regulatory asset is, and I'm kind of going to ask you something similar to Ms. O'Donnell. So the reserve imbalance has been, I guess, addressed for now. Moving forward, do you see something similar occurring?
It's very difficult to know, and it's a difficult issue because this period of storm costs and the unusually high cost of removal that resulted from them was relatively recent. It's difficult to know whether there's really a 3-year period after that increased a period of cost of removal. There's a 3-year period after that to the end of where we have data, where it's hard to know whether we're experiencing a kind of ramping down of those costs or a new normal of slightly higher cost of removal. I believe that for that 3-year period, the cost of removal incurred is still somewhat higher than the cost of removal being accrued through the present value methodology. So if that were, if we were to continue that into the future, it is possible that there would be a regulatory imbalance, a reserve imbalance again in the future. However, there are a number of ways that can be addressed in the next depreciation study. And that's not dissimilar to a case where, in the case of service lives, you might have a service life that is too long or too short. You expect to see, over or under recovery over a short period of time. That can be corrected from one depreciation study to the next. I think that Mr. Valkerinja's assessment, and I agreed with him, was that it's probably there's probably not enough data after that period of high cost of removal to know exactly where we stand. And then in addition to that, the depreciation rates and accruals that you see in the settlement agreement reflect, as you know an always complicated balance of compromises that happen in settlement. And so, we'll have to look at this again in the future.
Sure. Understood. All right. Thank you very much, Mr. Gannon. I appreciate you being here. And answering
Of course, Your Honor. Thank you.
Mr. Cleaver, do you have any follow-up for your witness, or my witness, whatever you want to call it?
Follow up, Your Honor.
Okay. Mr. Seegers,
No questions, Your Honor.
Mr. Nam,
No questions, Your Honor.
and Mr. Greger.
No, Your Honor.
All right. Thank you. Thank you very much, sir. All right. Mr. Greger.
Yes, sir. Would it be possible to call David Hoppick and David Valkerinja to the stand as a panel?
Yeah, absolutely. I mean, I don't know. I don't know if I'm gonna. I may have one question for Mr. Hoppick just to follow up, but yeah, sure, we can do that, sir. Gentlemen, can I get you to raise your right hand? You swear or affirm under the penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, you're muted, Mr. Valkerinja. We'll start with Mr. Hoppick. Sir, can you state and spell your name, please, for the record?
David, D-A-V-I-D, Hoppick, H-O-P-P-O-C-K.
Thank you very much, sir. And Mr. Valkerinja?
Valkerinji, V-A-L-C-A-R-E-N-G-H-I.
All right, thank you very much, sir. Mr. Greger?
Thank you, Your Honor. Mr. Hoppick, Mr. Valkerinja, do you have before you a document entitled The Joint Testimony in Support of Settlement of David Hoppick and David Valkerinja?
We do. Yes.
Thank you. Did you draft this testimony or were responsible for overseeing the drafting of this testimony?
Yes.
Do you have any corrections or updates to make to the testimony at this time?
There's one correction that I'm aware of that needs to be made. On page 6, line 2, you'll see on line 2, it says Exhibit 2, or I'm sorry, it says Exhibit X. It should refer to Exhibit 2, which is a page in the settlement. Those are the only corrections that I'm aware of.
Thank you. Now, with these corrections, if you were asked the same question today, would your answers be the same?
Yes.
Thank you. Your Honor, staff would like to have this exhibit marked as Staff Exhibit 18.
It will be so marked.
And we would also like to have that moved into the evidentiary record.
Right. Any objections? Hearing none, it's admitted.
Thank you, Your Honor.
Good morning, gentlemen. I was looking for Exhibit X, all week. I thought it was like the behind the scenes
Serious
exhibit.
document.
Yeah. Mr. Hoppick, is the system average, can that be boiled down to like a number, an actual number?
Yes, Your Honor. So the system average is the percent increase in total distribution revenue under the settlement, and that is 5.51%. So that is the percentage increase in the residential class distribution revenue. And if you would like, I did calculate a average summer bill impact and an average winter bill impact, and I'm happy to provide those to you if you would like.
Yeah. Yes, please, sir.
So the average summer bill impact for an average monthly usage of 998 kilowatt hours per month is $2.8. And the average winter bill impact, again, for an average monthly usage of 998 kilowatt hours per month is $2.67.
Thank you very much. I appreciate it. That's exactly what I was looking for, the 5.51% rather than trying to have me calculate it, which I'm sure no one would want. I don't think I really have anything else. Mr. Hoppick, while I got you here, on the extension of the eligibility requirements for the pilot, would you agree with Ms. O'Donnell that that's something that I guess new customers could migrate to, or do you see that just more as a another option for the customers whose rate class is closing, sir?
Well, the primary purpose was to provide, in my mind, a time of use rate option for the customers being migrated away from the RTOUND class. However, based on the proposed language that would make it available through 2023, I believe, it would be available if another customer, based on my understanding, for example, just decided to call up the company and request it.
Okay. All right, thank you, sir. And I know this wasn't in the settlement, but is there a lot of times when you know, there's communications with customers on issues such as this? I know staff and OPC are involved in some of the communications. Is that an issue here, or are we just going to rely on the company to notify customers, or you anticipate like a compliance filing type thing? Does that make sense, sir?
I do not anticipate a compliance filing. I do anticipate communication with all the existing RTOUND customers, explaining that this particular rate class is effectively closing to them, and then presenting the various options with an explanation of those options. So a comparison of the class R, the residential rate, the flat rate, kind of traditional primary option, with the time of use option, the time of use rates, and when the on and off peak periods are. And then potentially mentioning if the customer does have an electric vehicle, the electric vehicle time of use options as well.
Okay. Does staff envision a need to be involved in that process, or are you confident with the company with the company's communication with those customers?
I'm confident with the company's communication with the customers.
Okay, no need to sign off on a draft letter or anything like that.
I don't believe so. Staff's
Okay.
primary concern was migrating these customers off of the RTOUND rate because the rates are just so much higher, and it's basically impossible to save money on this class through any load shifting relative to the standard residential class. And that is being accomplished here. And I would also note that both staff and OPC, though in a bit different timeframes, requested that this class remain, and that the company come up with an additional alternative time of use class that kind of incorporates the lessons learned from the time of use pilot. And very happy to report that the company has agreed to do that with its next base rate case filing.
Yeah, okay. All right, very good, sir. Thank you very much. Mr. Valkerinja, I don't have anything for you. Mr. Greger, do you have any follow-up, sir?
No follow-up, Your Honor.
All right, thank you. Mr. Seegers?
No questions, Your Honor.
All right, Mr. Alexander, or no, Mr. Cleaver. Mr. Alexander's name was under you for some reason, so.
We're always together. No questions, Your Honor. Thanks.
Okay, thank you. And Mr. Nam, do you have anything, sir?
No, Your Honor. Thank you.
All right, anything else before we sign off today?
Your Honor, just one thing I would note is that in the settlement agreement on page 9, paragraph 13, the parties have agreed that in the event Your Honor issues a proposed order accepting the settlement agreement without modification, that the parties would request that become a final order 14 days after the issuance of your proposed order.
Yes, sir. I saw that, Mr. Seegers. I appreciate you pointing that out, though. So
Thank you.
That shouldn't be an issue. So, all right. Well, with that, we'll end today's hearing. Thank you all for being here, witnesses. I appreciate you coming and answering my questions. Everybody, stay warm and be safe this weekend.
Thank you.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. For the record, Your Honor.